Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, we're going to be discussing the issue of immigrant intent, specifically with respect to U.S. marriage and fiancé visas. Frequent categories of U.S. immigration or U.S. immigrant visas, and although the K-1 is a non-immigrant visa, it's effectively treated as an immigrant visa. One of the biggest issues involving this visa is what's called, or these visas, is what's called immigrant intent. The immigrant, or prospective immigrant I should say, basically the applicant for the underlying visa, needs to have the genuine intention to immigrate to the United States at the time they file for a visa there too. The thing with immigrant intent is the fact, what it comes down to is, yes, it's an intent issue, and one's intentions need to be genuine. One's intentions can change later. Let's say K-1 fiancé moves to the United States to be with their fiancé, they marry, adjust to permanent residence, and then a couple of years later they need to move abroad for some reason or leave the United States periodically. This is fine. This is perfectly acceptable. But that being said, immigrant intentions need to be genuine at the time the alien is both applying for their immigrant visa and at the time they're actually getting ready to travel to the United States. In another video on this channel, we discussed specifically the issue of domicile, or what's sometimes referred to as the domicile paradox, with respect to immigrant visas, especially those filed abroad or sought abroad in what are called direct consular filings or local filings at USCIS field offices overseas. And in some of these cases, the domicile paradox can come up, whereby they want to see that the American citizen has taken what are called, quote-unquote, affirmative steps to reestablish their domicile in the United States. Under those circumstances, the issue, again, I think one of the big issues that sort of sub-issue relates to is, again, this immigrant intent. They want to see that the family, the spouse, the married couple, or yet to be married couple, prospectively married couple, does genuinely intend to move to the United States and reside therein, at least for the foreseeable future. Again, unforeseeable circumstances may arise where intentions change, but at the time of immigration, the intentions need to be there and need to be genuine. In another video on this channel, we discussed maintenance of residence with respect to lawful permanent residence in the United States. That kind of plays in a little bit to this, but that's an issue that comes up later after an immigrant is a landed immigrant in the United States and has established their lawful permanent residence therein, or has adjusted over from K-1 fiancé to a lawful permanent resident based on marriage to an American citizen. That's sort of a different analysis than this one. Immigrant intent is what needs to exist at the time both the application, or the petition I should say, for the visa is filed, and it needs to be maintained throughout the entire process until the applicant has gone to the United States, has landed therein, established their lawful permanent residence. And much like what we discussed in another video with respect to the 30-60-90 rule and fraud and misrepresentation, you know, somebody going to the United States and sort of immediately turning around and changing their mind does look a little bit suspect. And may call into question one's intentions as far as immigration. Less of an issue where one is ultimately trying to get permanent residence and then something suddenly changes than it is with respect to using a non-immigrant visa in order to sort of circumvent the normal protocols for immigrating to the United States. It's somewhat less of an issue, but nonetheless, it is kind of an issue if one just immediately, the day after arriving in the United States, immediately leaves again. These circumstances can arrive where that can genuinely happen, and there's a genuine reason for doing that. But in most circumstances, the thing to take away from this video, one needs to have immigrant intent at the time that they apply for visas, such as a CR1, K3, IR1, or K1 visa. And at the same time, one needs to go ahead and maintain that intent throughout the entire processing of the case, as well as at the time that the immigrant is immigrating to the U.S. physically and enters therein, or is admitted therein. So these are issues that they're somewhat complex. They can be very circumstantial, but nonetheless, from a legal standpoint, intent is a very important topic.